Welcome to this Australian Society for Computers and the Law webinar on neurotechnology and the future of criminal law. It is supported by the UK Society for Computers and the Law. Thank you very much, Simon, in the background. First, I'd like to acknowledge the First Nations people of each of the lands in which we meet. For me, here in Sydney, Australia, I acknowledge the Gadigal people of the Eora Nation, their elders past, present and emerging, and extend a warm welcome to all First Nations people joining us this evening or morning, depending where you are in the world. Today, we'll be exploring neurotechnology and the law. Back in 2019, the New York Times reported that Elon Musk invested $100 million in Neuralink. And just 6 months ago, he demonstrated his technology with 3 pigs and the audacious vision of a smartphone-controlled brain-machine interface. In the same year, 2019, Facebook acquired Control Labs, signalling a move into neurotechnology and augmented and virtual reality. Are we moving into an era of neurocapitalism? Do we need a new jurisprudence of the mind? And what are the legal and ethical implications of this type of technology? Well, to explore these issues and others, we've assembled an exceptional multidisciplinary panel. Unfortunately, Nicole Vincent cannot join us today, but Alan has kindly agreed to speak for longer. Thank you, Alan. Our panel is moderated by Associate Professor Tyrone Kirchengast of the University of Sydney Law School. He is a member of the Sydney Institute of Criminology. And now for a brief bio on Tyrone. He is an international expert on the rights of criminal victims and access to justice. He is widely published, conducts comparative research across international and domestic legal systems, and on issues including the criminal law, digital crime, and procedural fairness, just to name a few. And he is also an expert advisor and commissions into inquiries such as those of victim rights. So thank you, Tyrone, for moderating today. I understand also you'll be joining the discussion. Thanks again, and now over to you.
Thank you so much, Marina, for that warm introduction and for the ability to participate and help moderate today's discussion. Let me introduce to you all Alan and Tara. I'll then say a few words about my area of research before we hand over to Alan and Tara for their presentations. Dr. Alan Mckay, author of Neuro Interventions in the Law, Regulating Human Mental Capacity, Oxford University Press. Alan is Deputy Director of the Sydney Institute of Criminology and is an adjunct lecturer at the University of Sydney Law School. Associate Professor Tara Hamilton. Tara is currently an Associate Professor at the University of Technology, Sydney. Her research includes neuromorphic systems, biomedical and neuromedical devices, analog and mixed signal integrated circuit design, and bio-inspired machine learning. Tara is author of over 120 academic papers and 3 international patents. She's worked extensively in the medical devices industry, including Cochlear and Saluda Medical, where she currently works directly with Neuro implants. Tara works with leading health, defense and technology companies, and she is focused on developing innovative solutions to real world problems. What a privilege it is to join these two today in discussion. As I said, I'll spend a brief moment of time introducing my interest in this field. Today's forum is on neurotechnology and the criminal law. So we're very much looking into these frontiers of the intersection of criminal law with this new emerging field and this emerging technology. And in many ways, all of the different issues, some potentially problematic or offensive, that these intersections may cause. My background in this area looks at the use of smart technology and smart devices, so basically mobile phone devices, and the different sorts of experiences, and looking at the more criminal law end of the spectrum, some of the problematic behavior that can emerge from people's use of smart technology. So the taking and distribution of intimate images without consent, what we might call revenge pornography, recording and distribution as one example, and image manipulation as well, where the technology is now verging on deep fake production, what we call deep fake production. Do we regulate it? Do we criminalize it? How do we go about that? My particular interest is looking at the traditional recourse to criminalisation and criminal responsibility through the act and the mind, what we call the conduct and fault elements, approaches to criminalisations that are long-standing over the centuries, but really there's a real challenge extending them to the new frontier of smart technology, and there is even greater problems, even more problems arise where it extends to neurotechnology, which is what we're talking about today. So I won't spend any more time on my background, but I'm keenly interested in this area and how we marry up criminal law, potentially, or whether we have to reinvent criminal law for the purposes of neurotechnology. But let me first hand over to Tara, who will be speaking to us about her knowledge of neurointerventions.
Great, thanks, Tyrone. Nice to see everyone. Good evening, good afternoon, or good morning, wherever you are. So my background is as an engineer, and I started my life as an engineer working for Cochlear, which is probably one of the most famous, especially if you're from Australia, neurotechnologies around, and possibly one of the earliest type of neurotechnologies as well. So today I thought I'd just take you through some of the neurotechnologies that are available and what the future might look like as well. And also a little bit about what makes these technologies interesting and make them work. So I've got lots of things on this slide, so I'll just talk a little bit about all of these pictures sort of are an example of a type of neurotechnology that is currently available today. So in the top right there is the cochlear implant. The bit with the tail is what goes inside a person's head. So that's the implantable part, and then the external part kind of looks like a normal hearing aid with a little coil on the outside, which communicates with the implant on the inside. The cochlear implant basically works by taking sound from the outside using a microphone and converting it into electrical pulses. And you can't see it in this picture because it's far too small, but on those little legs that are coming off the cochlear implants, there are little platinum electrodes that push current into the cochlea and give the nerves that have been damaged, give it some input that then the brain can decode and present some sort of sound sensation to the person that uses it. And by far, they've been the most successful neurotechnology that has been developed thus far. Other types of neurotechnology, in the bottom right there, we see the sort of classic EEG, so electroencephalogram cap, lots of electrodes put on the outside of somebody's head. And you end up seeing as sort of these sort of typical traces of neural activity on many different channels. And then this sort of technology has been used quite extensively to sort of show people moving things with their minds. So you'll see someone sit there and then they'll move a robot arm or something else. And a lot of this technology is being adapted for things like computer games and augmented reality type scenarios. It works best on bald people because there's a better connection. Hair is a real problem with this type of technology. And even though EEG has been around for quite some time, it's not a great signal. And so it's hard from an engineering point of view to do anything particularly useful for it. Our electronics and our technology is getting better to decode, but most of the better working electrical neurotechnologies are ones that are implanted, and those tend to be quite invasive. So if we look at there's a little picture next to the guy with the EEG cap, that is actually called the Utah array, and it's basically this spiky plug that they implant into somebody's brain. And they've done lots of studies with this. People who are quadriplegic with this device can actually use robotic arms and show quite a bit of functionality beyond what their current affliction has allowed them to have. But the issue is that you're damaging. You're getting something very pointy and you're sticking it into your head, and it's a very kind of, you know, nasty treatment. And even though the people that use them are like, don't ever want it to get taken out because it gives them so much freedom to be able to do things, it's not a great, it doesn't last very long. Your body starts rejecting this kind of sort of hammer technology, and so it's not something that anyone has had chronically implanted. The most, I think the longest is about 36 months with one of these devices. So the bigger problems for us in technology is working out how best to connect to the brain. If we look at the top left, there's a picture of deep brain stimulation, and this is a similar kind of device to the cochlear. And it usually is just a single electrode lead that gets put into the thalamus or the subthalamic nuclei, which is a part of the brain, which is like central station, the terminus, where all the connections, all the different parts of your brain kind of meet. And so it's been a target for stimulation therapies because it has so much connectivity to all different parts of your brain. While it has been successful, it's also it damages your brain. You know, you're putting something foreign into your neural tissue. There's obviously a lot of risks involved with that. And there's also a lot of side effects. Well, one of the side effects, which is quite interesting perhaps for today's discussion, is that people with Parkinson's who end up having deep brain stimulation tend to have changes in personality, and they tend to do things sort of uninhibited type of way, you know, where they might have been quite a conservative person, might find themselves going to a nudist beach or something, which is very out of character. And these sorts of things have been quite well documented. Part of that is to do with the fact that Parkinson's is related to dopamine, but definitely when we're putting these devices in, we are changing the balance of some of our neurotransmitters like serotonin and dopamine. And is an important thing to consider when we're thinking about you know, what are the effects of actually interfacing with the brain.
So yes, so the middle image is transcranial direct current, or there's another type called transcranial magnetic stimulation. And these devices sort of sit on top of your head, and you might actually see them with some computer games. People are starting to look at them. They've been heavily looked at by the military because there are claims that transcranial direct current stimulation can improve focus. Now, there's a lot of question marks over the validity of some of the studies, but there does seem to be enough evidence that in certain people it does have an effect. And the effect is sort of not persistent, although because it's fairly new technology, the kind of chronic use case is not something that we know yet. So this is sort of a device that's looked at particularly for improving concentration. People have also said that it can affect memory. So we're not really, it's still a new technology, but it's being experimented with quite heavily. And if after this you go on to YouTube and type in transcranial brain stimulation, you will find how-to videos so that you can just make one yourself at home. So these things are sort of out there and being experimented with, and they certainly are they're non-invasive and quite accessible. So whether or not they have any impact is something that, well, we're all still trying to find out. Just under that, you'll see a picture of a person's head. This is the best picture I could find of Elon Musk's Neuralink thing, which looks quite similar to the deep brain stimulation use case. My understanding is that they have a better way of connecting with neurons that doesn't involve the kind of electrode lead that's used by cochlear implants and by deep brain stimulators. But it remains to be seen as to how successful that will be. I think the biggest thing to stress is that neurotechnology has been somewhat held back, if you could consider all these things that we already do being held back, but it's been held back by the fact that we don't have a great way to interface with the brain. And so Elon Musk's company is actually looking for better ways to connect with the brain, but there wasn't anything particularly in his presentation with the pigs, there wasn't anything particularly surprising to neuroscientists. He didn't present anything that hasn't been seen or done before, but it remains to be seen as to whether or not this connectivity regime is actually better than what we've had before. Certainly, from my point of view as someone who's worked in this industry, we are really not good at connecting with the brain in a way which doesn't destroy it, and which allows us to have a level of accuracy and sensitivity so that we're not actually hurting tissue. The final one is in the bottom left there, and this is an interesting, I don't know whether device is the way to use it, but there's a very famous neuroscientist called David Eagleman that's written a lot of books, and he has a company that's looking at giving people extra senses. So this vest has electrodes, and using the interface between touch and whatever you're trying to get a new sense for. So a use case that he gave as an example was he had a bunch of people wear this vest, and the electrodes on the vest stimulated, so it felt like touch. It was like little motors. And so, it was indicative of the Earth's magnetic field. And these people walked around with it for a long time. And then eventually you could put a bag over the head and drop them somewhere, and they would be able to navigate back to where they were coming from just by using the Earth's magnetic field, which is kind of insane in so many ways. So on the next slide, I talk about how we have, why brain science works, I guess. So if we look on the right, we've got the technology that we're used to. Everything that makes our mobile phones and our computers work is silicon, basically. Silicon technology that's been around for quite some time, is amazing and has changed and improved our lives in many ways. But it's static. I build a circuit and it doesn't change. It's built, it's done. The thing that makes neurotechnologies work, and the thing that makes David Eagleman's extra senses work, is the idea that incredibly is fairly recent, at least the scientific acknowledgement of its truth, is the fact that the brain is extremely plastic. So in this picture, I show some functional MRI scans of somebody who had a stroke and lost all motor function. So the motor cortex is sort of in the middle of your brain, sort of up around here. And this person lost lots of connections. There was a lot of damage in the area where the stroke occurred. In 5 months, we can see no activity at all, especially related to brain function. By 8 months, you can see a little red and yellow in the middle. And by 11 months, there's almost full restoration of motor function. This is the brain working out again how to rewire itself. Before, we used to think people would have strokes and then that was it. They lost their hand function, they lost their legs function. But by doing rehabilitation, physical rehabilitation, actually getting your nervous system to work, your brain will find new ways to connect. There are stories of children who have had seizures and therefore had to have half of their brains removed. And if it's done at an early enough age, they live completely normal lives with only half their brain. So all of this neurotechnology is only working and is only based on the fact that we have these amazing brains that are not like our technology that we build once and then it's done. It's this incredible hardware that reconnects itself, that learns, that allows us all to continue to learn and accept new ideas and find out new things, because our brains are extremely plastic. And as engineers and technology people, we actually leverage the fact that the brain can do this. And that's the power and the danger of neurotechnologies.
Okay, thank you very much, Tara. Some amazing insights there into what is possible in brain science and neurointerventions. I'll turn over now to Alan Mckay, who will look into other interventions and aspects of criminalization. Thank you, Alan.
Thanks very much for the introduction, and to Tara for explaining things that I certainly wouldn't be able to. So, okay, so I'm going to talk about some of the criminal law implications of all of this, and I'm going to talk about some criminal law issues that I think might start to emerge. So of course, neurotechnologies are already currently employed in a sort of criminal justice context. So I've been involved in a project called the Australian Neuro Law Database, where we look for cases where brain scans are the kind of large, clunky neurotechnologies that are used in hospitals find their way into expert witness reports and maybe in a sentencing matter. But I'm going to, in this talk, start to think about the possibilities of people committing offences in a way that's mediated by neurotechnology. So I'm going to think about a brain-computer interface, so a way of controlling a device by this mental activity and neural activity, and I guess I'm going to argue that it could be quite disruptive for the law. There's no cases yet. I'm not familiar with, I haven't heard of any cases worldwide where someone has done this, but certainly the technology is currently available, which in principle would enable a person to commit an offence by way of neurotech. And it may have already happened, but I don't think there's any cases. So some neurotechnologies, as Tara mentioned, were used in the context of people with some form of disability or movement problem moving. And I'm just going to show a very short video from Stanford University, which I think it's about 3 minutes, but I think it's useful to see somebody working with a brain-computer interface before I talk.
Stanford University.
The goal of our research collaboration is to restore function to people with paralysis. This can be people who have a spinal cord injury, people who have a neurodegenerative disease like Lou Gehrig's disease.
We're able to eavesdrop in on electrical activity and slide a cursor across a keyboard and type out messages.
Our research is focused on an area called the motor cortex. The motor cortex is responsible for generating movement on the opposite side of the body. Even in cases where you have paralysis, those cells, those neurons in that area of the brain are still active.
We can surgically implant a tiny electrical sensor that's made out of silicon that has 100 tiny electrodes that just sits on the surface of the brain, and it's able to pick up on the electrical activity of individual brain cells or neurons.
We record tiny signals from those neurons, those brain cells, called action potentials. We can then take those signals and decode them using a computer. We can manipulate them once they're in digital form like any other data.
So all you need to do is imagine moving your right arm, for example, to the letter T on a keyboard, and it'll slide out to the T. And in addition to that, we're also able to detect when you wish to select that letter T.
Our participants were able to type at rates anywhere from 12 to up to almost 40 characters per minute, which translates to, in the best cases, about 6 to 8 words per minute.
The interface that you could control with these decoded neural signals is really many-fold. So you might instead wish to control a robotic arm. You could imagine also interfacing with your home, wirelessly sending signals to your thermostat, open and close doors remotely. This is really the business of Internet of Things.
It's important to keep in mind that this is a phase 1 study. So this is really a safety study. It's a feasibility study. It's not meant to be the definitive device that one would deploy. It will obviously be important to have these systems be completely implantable, wireless, able to function autonomously, not require a technician to set them up. So these are all areas that we're researching throughout our Brain8 consortium, of which we're a larger part. But I'm very confident that in the not too distant future we'll have systems that are deployable and able to provide help for people with paralysis.
Yeah, I mean, the video was just to give people a general sense of somebody using a BCI and controlling, in that case, a cursor in order to compose text. And that's something I'm going to be looking at. Of course, as I think Tara mentioned, that you get invasive neurotechnology that's implanted into the brain. And then there's non-invasive technology like EEG that Tara already mentioned. So there's a lot of commercial excitement, as Tara mentioned, and I think Marina also mentioned some of it. So there's Facebook, Elon Musk company, Neuralink. This is now a few years old, but the Economist had a special on it. And so Facebook own a company called Control Labs. But I'm going to imagine somebody using that particular form of neurotechnology, brain-computer interface, and committing an offense. And let's start off with murder. So many of you I think, will be legally trained, and if not working in criminal law, might remember the mens rea actus reus distinction. So if we think about the elements of crime, the prosecution have got to prove the elements of crime, at least in terms of serious offenses. That involves the actus reus element, which in the case of murder might be an act causing death. I'll leave omissions to the side at the moment. And here in this picture, the silhouette of the man using his body, he's using his hands to stab. And it doesn't look like an accident, does it? It looks like he's intending it. And so he might have the intention to kill, and that might be inferred from circumstances. And this looks like a murder that's about to happen in that picture. But the thing I want to focus on is the conduct element, the actus reus element. There's an interesting question as to what's the criminal act here? What was the act if somebody doesn't act by way of the body, but what acts by way of a brain-computer interface? So you can perhaps see a picture on below the silhouette picture of a person who's engaged in controlling a brain drone with their brain. And so they're controlling this drone. They're using an external headset, which is detecting the neural activity associated with various things like maybe mental acts of the imagination, like in waving the hand or something of that nature, and that sends it right, and kicking a football might send it left, in this act of the imagination. So let's assume that person just controls the drone and she flies it over towards the person in the background and knocks them over and kills them, and perhaps that's accompanied by an intent to kill. So you might think, okay, so what was the criminal act here? So it seems to be a non-standard criminal act. The thing that's non-standard about it is there's no moving of the body. She didn't pull a trigger. It's not an omission. Could the criminal act be a thought? Let's say she controlled the drone, and the command that the drone understood, I'm using understood loosely, that the neurotechnology took to be a command to fly into the person was a hand wave, an imaginary hand wave. Could that thought be the criminal act? Was that the conduct constituting the actus reus? That seems strange. I mean, the criminal law is used to more bodily acts like stabbing or pulling a trigger or something of that nature. So in a paper that I published called Neurobionic Revenge Porn, it's a longer title, but that's the gist of it. I envisaged somebody committing the intimate image abuse offense. So that's the offense that's colloquially known as revenge porn. And the way they did it was they, instead of maybe using a trackpad and using their fingers to type on a computer or keyboard, or their phone, they used a brain-computer interface to assemble images, maybe compose some offensive text to come with it, and upload it onto social media. And I considered it in the context of the New South Wales intimate image abuse offences, and looked at the case where an offender, let's call him John from Surrey Hills, has non-consensually uploaded intimate images, making them available to many other people, but it's all done by way of brain-computer interface. There's no bodily act anywhere, and he does it by controlling a cursor. So the BCI algorithm detects the neuroactivity associated with things like him imagining waving his hand, imagining various bodily action. That's how he gains control over the cursor and selects text and images. He assembles the images, and then finally he imagines himself waving his hand, and the mental act triggers the upload onto social media. And he knows that's what's going to happen, and it's sort of like the equivalent of a more orthodox intimate image abuse offender who might do it by way of typing and controlling a trackpad or a mouse on a computer. So the images all go up onto social media in this kind of totally disembodied way, just by a series of mental acts, the BCI detecting the neuroactivity, and John gaining control that way. So a legal question might be, okay, so what was it John did that made available the images to people on social media? What was it he did that made them, clearly they were made available? Well, what did he do to make them available? So he didn't engage a traditional bodily action, or use his hand to control a trackpad. So there's a few possibilities what the court might say. He looks culpable, doesn't he? It doesn't look like there's any moral reason to let him off the hook because he has used a non-orthodox way of uploading the images. So what might the court say the conduct constituting the actus reus was? Well, perhaps they might say it's a mental act. So the final step, where he was just he composed all the text and composed the images, and he's just deciding whether to upload them, and he imagines waving his hand, and he knows that will upload them, and he goes ahead and he imagines that. So they might say that mental act, that mental act of the imagination, that was the conduct constituting the actus reus. So that seems like a radical step, like we in the criminal law have learned that there's the mental, there's the mens rea, and that's the mental part, and then there's the conduct part, and that's sort of bodily. And now it seems like there's kind of the distinction between the actus reus and the mental is not quite so firm as it was. You know, see, that's one thing. And an interesting thing is that will, I guess, become clear is, you know, a question of whether people are as good at controlling their mental acts as their bodily acts. And so if I say, don't lift your hands, then I think it's pretty easy not to lift your hands. If I say, don't imagine a white bear, it's sort of harder not to imagine a white bear. So there might be a difference in control. And, you know, it seems a bit startling. Okay, well, now acts of the imagination can, in some circumstances where the impact on the external world, be criminal. Bit strange for the criminal law, but that's one way the criminal law could go. So another way it could perhaps go is it could say, well, actually, John has used his body to upload the intimate images. What he's done is he's kind of intentionally brought about some activity in his motor cortex. He's kind of jiggled his motor cortex, and that was bodily. You know, by imagining a hand wave, he's jiggled his part of his brain, his motor cortex, and that was the act. So it is still a bodily act. That's kind of weird, isn't it? The idea of when you think of something, you jiggle your motor cortex or your body. I mean, maybe that's the way the criminal law could go, but it seems a little strange. Let's assume that John, the defendant in this situation, is that he has an implanted brain, an invasive brain-computer interface, and he uploads the images that way. Well, you might say, well, actually, John, in that case, John's a cyborg. He's part organic, and he's part wire and silicon. And what he's done is he's used his body, and he's used the inorganic part of his body to upload the images. So he's flowed signal through the wire part of his body, and so it is a kind of bodily act. But then you might say, well, okay, well, where does John end and the internet? Let's assume the wire goes out onto the internet. Where's the end of John? Where's the end of the defendant in that situation? But that might be a way that the law could go in deciding what it was that John did that uploaded the images. So I guess all the options seem a bit weird. You know, none of them seem completely standard, and they, you know, I think that if a judge ever had to decide what the conduct constituting the actus reus was, that it would involve a bit more thinking, maybe a bit less help from the precedents and legislation than might ordinarily be the case. I mean, I think another possibility is that they might say, well, the conduct constituting the actus reus was sort of complex, and it involved mental act, neuroactivity, and flow of electrical signal. But that just seems to further complicate things. I think it's I can't see how a court would say that he's not guilty just because he's acted in a non-standard way, and I don't think they should. That seems morally wrong as well. It seems like he is just as guilty, but it's an odd situation for the law. And I guess one thing that we might start to think about here is, okay, what happens if the BCI malfunctions? So it wrongly decodes a signal. That's one issue. Another issue might be that the BCI is a bit of technology, and technology is susceptible to being hacked. So what happens if John's BCI gets hacked? So I guess what I would argue is I don't think for a moment that he would be found not guilty, but it might require a bit of a rethinking of what the conduct constituting the actus reus was. What about sentencing? I'll just say something quickly about sentencing. So let's assume that in between, let's assume John acts by way of a brain-computer interface that's implanted. Let's further even imagine that that's the only way he has of engaging with the internet. So let's assume that before sentencing, he gets his BCI reprogrammed in such a way as it makes it hard to engage in intimate image abuse, or at least very difficult. So perhaps it might be possible to say, let's assume he gets convicted, and his legal counsel say, well, don't worry about John in terms of recidivism, because his device has been reprogrammed. It's now quite difficult for him, or impossible for him, to upload intimate images because the device will detect that. So you might say, well, is that rehabilitation? Like, if the device is part of him, you might think, oh, well, maybe there's a sense in which it's rehabilitation, but it seems like a non-standard form of rehabilitation. Seems to raise the question of what is rehabilitation. Yeah, so that's an interesting question. And, or you can even imagine a bit of neurotech that's programmed to deter. So of course, judges, when they sentence, one of the things they have to consider under Section 3A of the Crime Sentencing Procedure Act is deterrence, and that includes general deterrence and specific deterrence, so deterring the offender. And maybe perhaps the device could be reprogrammed such as that if John were to start looking at intimate images and assembling them, there could be a warning. A warning could be automatically produced by the device, which reminds him that he's already been convicted of an intimate image abuse offense, and next time he might get a more severe punishment. And so could John say, look, to the judge, look, don't worry about deterrence. I've taken care of that. I've got this automated deterrence system that's built into my system now. So the interesting question might be is, could the criminal justice system start to ask people like Tara to get involved with deterrence and rehabilitation, and should engineers be engaged in that kind of project? So there's some interesting questions. I'm just going to end now. A final point is to say that I've been working on another paper which I'm going to present at the Julius Stone Institute at the law school, at Sydney Law School, on Thursday, and that also looks at sentencing, and it looks at the possibility of using neurotech to address a schizophrenic person's mental condition in the context of sentencing. So if anyone's interested in that, by all means register, and it's free to register. And it's a paper I've worked on with a scientist who's working in neuroscience, a neurologist who's also an ethicist, and some other ethicists. So it's like a kind of interdisciplinary paper. So in terms of what was the Criminal Act in a criminal responsibility context, the courts will pick one or more things, but they all seem a bit strange. Where do we end, and where does cyberspace begin? And might engineers start to have a greater role than they currently do? They already have some role, don't they, in criminal justice with global positioning services, GPS systems in the context of monitoring the position of some offenders who are on various forms of bond, like intensive correction order. But could that role get bigger? But anyhow, the upshot is that Neurotech could be disruptive for the criminal law in the ways that I've described, and quite frankly, in many others as well. But these were just examples. Thanks very much.
Okay, great. Well, thank you so much, Tara and Alan, for such engaging and informative presentations. So much there for us to think about, and really so well connected one after the other across the different intersection of technology, new technologies, the interface, and then Alan's comments on all the types of problems, the use and potential misuse, unintended or otherwise, that could cause, and ultimately then for the criminal law. There's been some comments coming through in the chat and questions coming through in the chat about this being such a grey area and a ghost in the shell, in the machine type issue as to the technology. Yeah. I have a few thoughts on extending out principles of criminal responsibility into this area, but perhaps before I say anything, we might go to some questions, specific questions that have come through, maybe for Tara first. Should we be building devices without knowing the full scope of their impact on a person's brain?
I would say no, but the history of engineering is if we can, we do. And often the case is think about some of the scenarios, like we saw the video that Alan showed. A lot of the times it's posed to us as a way to give back function to people with disability, and everybody's afraid of having, becoming a quadriplegic or having a loved one that way. And so the technology that we develop could help cure that person, or at least give them back some function. So, it's never an easy question for the engineers, should we? Because we can often think of all the reasons why we can make the world a better place by doing it. So yeah, I mean, the brain is the most complex thing in the universe, as far as we've found so far, and nobody really knows how it works. We've come a long way over the last 20 or so years, but for the people that can hear now because of cochlear implants, or the people that have got some functionality back because of Parkinson's disease and deep brain stimulation, can we tell them, no, you can't have the technology because we don't understand the brain yet? It's a very difficult question to, it's a hard one, and I don't know the answer to it.
Yeah, absolutely. Thank you. And just a call out for any ethicists that are joining us. If you have any questions about the difficult issues that arise, whether it be criminal law or otherwise, we'd like to hear from you as well. Just continuing on from that, Tara, if I can, you mentioned engineers. Should it be engineers that decide what is developed and what is not developed? Is there a need for engagement across other specializations? I mean, would you want to bring in, for example, the criminal lawyers to look into what technology is potentially feasible or permissible?
I mean, there's been examples of people hacking into pacemakers, for instance, because there's no security put on those type of devices. There are now, but I mean, there have been incidents of those sorts of things, and that's because the engineer was building something for a function and didn't think about all the other things that could happen.
Dick Cheney was worried about that when he was president, I understand, and had his device. Right. Oh, so when he was vice president, had his device moderated.
That's right. I do recall that. Yeah. So I mean, people have shown that you can hack in. A lot of these medical devices don't have any kind of security on them at all, because nobody thought of that. So certainly a more cross-disciplinary approach to putting together an actual product that goes into people would be a much better way of finding, or at least exploring, some of the issues that can come up with these devices before they get put in someone's head. So yeah, I think that that should be a thing, that there needs to be some sort of, you know, coming together, you know, people's throwing out some, what happens if this happens, what happens if that happens. As engineers, we do these sort of validation and verification, we do fault analysis, but it's always usually at the technical level, not at the higher levels of what if it goes wrong and the person, you know, goes
absolutely.
on a rampage.
Yeah, just to follow on from that, in terms of guiding technology and whether it should just be engineers making those decisions, I've been involved with a group called the Neuro Rights Network, which is a group of well, it's scientists, ethicists, and lawyers, and we are looking at you know, ways of trying to guide technological development with human rights considerations in mind. And the Chileans are the country Chile. They're in the process of changing their constitution and passing some legislation called the Neuro Protection Bill, and they're putting neuro rights into the constitution. And this is kind of underway now. And as I understand, it's passed through the Senate and is likely to pass into law. And so they want to be on the front foot in guiding sort of responsible development of neurotechnology with interdisciplinary panels. And Spain is following on their path, and you know, this is a legal trend that might start to spread out.
Yeah, thanks, Alan. We've got some questions coming through on the chat. I do apologise, of course, if I miss an individual question, but from Felicity, what guardrails will be built into the process? I think you've been talking both about that. And then a follow-up question, how can the legal profession begin to consider the concept of a flexible guardrail? So I guess we've got sort of two suggestions there, a guardrail built into the technology itself, and then perhaps some sort of legal development, an extension of principle perhaps, that allows us to extend conventional legal principle over to, as I said at the beginning, this new frontier where mind and act can become blurred.
Yeah, like in terms of guardrails, there's a lot of work that you have to do in order to get something that's allowed to be implanted into somebody's head. So from a medical point of view, there's plenty of guardrails, and because that exists, there would definitely be the scaffolding for a wider, you know, to create a wider investigation of a device, not just looking at its effect on the physical tissue, but also looking at its effects more broadly on the person and on their potential behavior as a result of this and so forth. So it could be incorporated, but it certainly doesn't exist right now.
And I guess in terms of whatever form the guardrail or guardrails take, another thing is, you know, you might think a consideration is what kind of impact might this stuff have on a wider society? You know, let's say neurotech starts to get used for enhancement, and then we all have to compete with each other. We all have to you know, get enhanced or fall behind, and then you're negligent if you're not enhanced, or maybe to go back to criminal law, you do something and someone dies and it's gross negligence manslaughter because everyone else is superhuman and you didn't bother to make yourself superhuman. You know, there's a
yes, that's a very interesting point, Alan. That's almost beyond the immediate future of neuro enhancement that we're considering, when neuro enhancements become so normalized that the reasonable person is themselves enhanced, and then a person who chooses not to be, all of a sudden is held out to a standard that they can't possibly reach because they're not enhanced. So that's a very interesting point, and another challenge. Just as Tara and yourself were giving your presentations, I was thinking about the principles of criminal responsibility that we use to sheet home responsibility across, as we've all mentioned, fault elements, or the mind, the mental element, or the behavioral or conduct elements. And in certain respects, if an enhancement, a neurobiological, neurotechnological enhancement is done consensually, and everything we've spoken about is about a consensual enhancement to the person. And so long as that person's behavior, then, even if it's controlling a drone, for example, through an implant or through a device, and then through that drone, you send it off into somebody and that causes an injury or a death to someone, or a destruction of property, whatever the criminal incident may be, or criminalized incident may be. So long as that enhancement is done consensually, then any behavior that potentially follows is what we would call willed behavior. It's a bit like the consents to harm, where a person consents to a body modification or an implant, and that implant might perhaps give them, like they might put an implant in their hand or in their arm that gives or adds extra strength to that arm, so that when they strike or punch, they deliver more force. This is just an example. So long as it's operating within the parameters of what they have consented to, I don't know if criminal law would have a problem necessarily of extending out liability on that basis. I could be wrong, but there certainly is ground within, I think, existing principles to extend out. And I think that's the beauty of the principles of criminal responsibility. They are so adaptable and flexible, even to the unknown, which is why they're so long-standing. And it goes the same for mental elements, the mens rea. We, for instance, have for many centuries now the law of attempts that quite adequately deals with incomplete actus reus, and then an inference from the incomplete actus reus. Attempted murder is an example. Well, in an attempted murder, the victim isn't dead. So you have to then extend out in time the death of the victim. So it is possible for the law to deal with what is not known and what is incomplete, and to look at what is there and to draw inferences from it. I think one of the really difficult points, the grey area, as our audience has pointed out, is where you start to blur the line between actus reus and mens rea, because the criminal law does proceed traditionally on a basis of clear separating out of mens rea and actus reus, mind and conduct. So where, for instance, you have the enhancement or the implant affecting what a person is able to think in the first instance. So in essence, the technology is in control of the person's mind. The person's mind is not in control of the technology. So where the technology is introducing a thought or changing a pattern of thinking, is it the person's subjective thought, or is it something else? And that, I think, introduces a problem for the law, but the law then overcomes that. For instance, if you introduce a technology that you know will take over your mind in a particular way, and that is operating within parameters, and within its operational parameters, you then go about a course of action which is criminal, which causes criminal harms and injuries and damage, then it might be that, again, you come back to a conscious act of enhancing yourself such that the operative parameters of the implant will make you more aggressive, or whatever the operative parameters are. Where that malfunctions, that's something different. It's a bit like a person who, for want of sleep, gets in a motor vehicle and drives the motor vehicle and just suddenly falls asleep. But they've had a good night's rest, they've not driven far, and they collide with someone, or there's a collision and there's an injury or a death, and that is a liability that's not seen to be conscious and thus can't be sheeted home as a criminal act, a willed conscious act. But if a person, for instance, parties all night and is sleep deprived and then sets off on a 12-hour car trip and after 6 hours falls asleep and causes an injury to people or property, then the fact that they were aware of their deprived state allows that the fact that they were asleep is therefore not relevant to then therefore connecting that as a conscious, voluntary and willed act, because they were aware of the parameters of their circumstances. They were so sleep deprived that they could well fall asleep, which could then, behind the wheel of a car, cause such injury. So I don't know if there are any direct answers to overcome every single example that's been offered up by yourself and Tara in this discussion. But I guess my point really is never underestimate the inherent capacity of the principles of criminalization, of criminal responsibility, that have so served us well for centuries. You know, actus reus and the development of mens rea over the last few hundred years. Don't underestimate their inherent flexibility to adapt to the unknown. They're adapting to digital technologies, to smart technologies. There's controversies around the extent of the flexibility and the breadth of the individual principles as they apply to the act of using a mobile phone, to the act of to the fault element of intent or recklessness. Should it go to objective fault, or should it go to negligence, which really falls outside of fault? But the law can, and principles of responsibilities can adapt, as I think they will, to this new frontier. But of course, there's always going to be challenges, and still there will be gaps. And when the courts start having to grapple with this, I think we'll start to see a real attempt to extend out, as the courts have always done, extend out the traditional categories, and that will begin to tease out whether or not we need perhaps statutory reform, or I think it was suggested already, a whole new way of conceiving of criminalization in this area. So I'm not sure if there's anything you've got to say to that, Alan or Tara, but certainly, you know, criminal law is amazingly adaptive, and that's why, you know, the principles stand by us so well.
So in response to that, I think, it's certainly not my contention that criminal law wouldn't be able to adapt. And in fact, I'm sure it will adapt. But I guess, you know, like it's interesting to compare with other technologies, you know, so for example, you know, like internet crimes, you know, I remember sort of people starting to use the internet, and then this kind of question and creating new offenses like hacking and that kind of thing in response to, and then subsequently things like the revenge porn, intimate image abuse offenses. But I guess these things are sort of at, you know, they're like chapter 11 of the criminal law textbook, whereas this thing seems a bit more sort of central to it, and the adaptation, which I don't for a moment think won't happen, might be in chapter 1 or chapter 2, where it's the you know, the elements of crime rather than new offences, and how things might or might not fit into different defences.
I think we've got some good questions that extend on that, Alan. Just to go to the chat, we've got a good one here. From a materialist perspective, mental states and actions are simply physical states. So neurobiological states, I guess, brain actions, brain chemistry. Has the mens res, actus reus perspective been wrong all along? Well, that to handle that one easily, Alan?
Well, yeah, I think that is an interesting question. And some people have said that in the past, before Neurotech, that the criminal law is committed to a weird form of dualism in philosophy of mind that doesn't hold up anymore. And I think an interesting question is that, in some of these questions, I think the law could benefit by hearing some arguments from philosophers of mind, because that might be another kind of resource that the law could draw on as they navigate through this issue. And maybe as the questioner said, maybe the law has been has subscribed to a sort of strange form of metaphysics and philosophy of mind.
Yeah, I would have to say, I think that sounds about right. It's not just biology and brain chemistry and the physiology of the brain, so to speak. Criminal law, I think, has developed over time as our understanding of the mind has developed, but not mind in terms of biology, but mind in terms of the thinking person and the ability to think rationally. So that's really beyond the biology. It is a branch of philosophy in many ways, yes, and certainly the criminal law has dwelled on that significantly. There are other questions. Let me try and get to as many of them as I can. Here's one from Rita. For you, Alan, can you tell me a bit more about the actual projects where Neurotech is currently used in the criminal justice space? Not the hypothetical ones, but the actual projects.
Yeah, so the it's really it's predominant. So as I sort of briefly mentioned, there's a project called the Australian Neuro Law Database, which is it's an open access database. You have to register, but there's no charge or anything like that. And it's a joint venture between Sydney Uni and Macquarie University, which I've worked on in the past. And what we try to do is find cases where neuroscience has been discussed in the law generally. I mean, I was sort of involved in the criminal law cases, but it goes wider than that. And and so we look for cases where evidence of brain abnormality, maybe brain tumor or dementia or stroke, has been maybe referred to in sentencing, maybe in mitigation to show that an offender has got a mental condition. And in some of those cases, the expert witnesses, so for example, a forensic psychiatrist might refer to some evidence of the offender of having a brain scan, and the brain scan looking a bit odd. And then the question is, and so that's it's a hospital brain scanner. It's not like the kind of things that we're talking about, Elon Musk and that kind of thing. It's a more traditional, old school form of neurotech. But there's a number of cases, and there's been a big debate in an area called neuro law about what should the law make of brain scans. In the law we tend to. The focus is really on a kind of folk psychology of mental states, like intentions, and what did a person foresee and that kind of thing. And this, by introducing brain scans and frontotemporal dementia and that kind of thing into criminal justice, it's like this weird scientific thing that's kind of encroaching into the criminal law, and so these are the kind of cases where neurotech currently has a role.
Yes, in the current world, the real world as it is today. Thanks, Alan. We have another question from Jing that goes to the holding an AK-47 or a rifle triggered just by looking at it. So is the first step to license? And then to insure perhaps, and then maybe to look at deterrence through criminalization. Maybe if we go to Tara for that one, in terms of these technologies, if there is the possibility that they could lead to some what we might call broad wrongdoing, misused intentionally or otherwise, from the individual recipient of the technology, or maybe because of an inherent design fault through the engineering process. Is it something that we can license and try and control as a risky technology? I think you know, in that sense. Difficult question, but interesting.
Well, in that case, I think we could do it today. Like, I think I could rig up, if I had an AK-47, which I don't, but I think I could rig it up to automatically fire on a particular signal from my brain. I don't think that would be too hard to do.
And certainly licensing may perhaps provide an extra regulatory step. And where there's a problem, the answer is always, let's regulate it. But these are also therapeutic technologies. And you certainly wouldn't want to intervene in the course of a therapeutic intervention.
Yeah, I mean, the other thing is that it's just so low tech, like that sort of thing, to create a brain interface. Like, it would be really hard to prove that they, you know, that they were breaking a law by putting things together in a particular way.
Just on the regulation thing, you know, there's an interesting distinction between the invasive technology and the non-invasive one. And, you know, so Elon Musk's company Neuralink, they're going through the FDA approval process, and they've got some sort of preliminary, very, very preliminary hurdle in that. They've passed through that. But then there's a question about regulating non-invasive neurotech, and, you know, they're just consumer devices. So there's many devices that are on the market, and they just seem to be unregulated. And
that sort of links up with a question from Linda on the Q&A. She was asking about, are there ethical frameworks around what's acceptable for human augmentation, especially in the context of Neuralink's device? And yeah, just as Alan said, like, from a medical device point of view, I have to pass lots of hurdles in order to get a product and bring it to market. But if I call it a therapeutic or health device, then the bar is much lower for me to put a product onto the market. And so from that point of view, from a technical point of view, there aren't any frameworks as to an ethical, you know, like there's ethics as an engineer, there's ethics sort of, you know, loosely as humans, but there's no real framework on which, you know, I go out and say create one of those cranial stimulators. There's no real framework around which I have to play in order to put that device out there. I can go on Kickstarter and do it today. So as long as I don't call it a medical device, as long as I don't say it's going to cure you of your disease, there's not really many regulations. There's sort of electrical standards, but that's it.
Yeah, we have another question. Thank you very much, Tara. Another question from Linda that goes to Neuralink's implantable brain-computer interface allowing for consensual telepathy. And in the event that a crime takes place, what's the effect? What is the effect of consent on the actus reus? There's a few different ways to come at this, but in some respects, it goes to the nature of, I would say, the knowledge of the interface and whether or not that's something that the individual has consented to. And if two people have consented to the interface that allows them to think with a degree of what we might say telepathy, a non-verbal communication, then you would still use the traditional approaches to criminalization, which is to, and it's always tricky with consent. I have to say to my students, never ask mens rea questions of the actus reus, that you separate out the subjective decision from the conduct element, which is consent as a behavior, consent which is something to be performed and then registered in the mind of the offender, which then becomes the mens rea element. So I suspect we'd still approach these sorts of tricky situations as far as we can with conventional approaches. It just might be we take it back to, well, was the interface consensual? If the interface was consensual and operating within parameters, then you look at what can be evidenced by way of subjective thought and what can be evidenced by way of an acknowledgement of consent, or usually it's an acknowledgement of the conduct element of a lack of consent, there not being consent to do something. But the technology does present a novel factual circumstance. The law is not, we don't have precedent really of those novel factual circumstances.
Yeah, I guess.
So I'm sticking with the law can adapt, but yeah, I mean, maybe I've got too much faith in criminal law here.
Well, I guess it also ties in with Rod Sharma's question about sort of a ghost in the shell type situation where, say, the person who was, they got the implant with, they consented to it, but then someone hacked them and then gave them ideas and made them do things that they didn't think were gonna be, they didn't get it for that. They might have got it for some other enhancement, but then it got sort of taken over and they became like, that would be a difficult thing to prove or disprove, I imagine.
Yeah, well, in some respects, yes, and in some respects, no. Once it's taken over, or if there's an error with the technology, unforeseen error with the technology, it breaks down or it introduces thoughts or ideas or a stimulation that it was never intended to, it's operating beyond parameters, then it would be that the person's behavior, however devastating, the consequence would not be criminally liable. It's a bit like, getting into the car and falling asleep, but, you're well rested. There was no reason to suspect that you were going to fall asleep behind the wheel and injure someone, kill someone, or damage property. The law can only go so far in those circumstances, which is why you have this major public policy around stop, revive, survive, because the law can't criminalize every bad outcome. And it would be the same, I would think. It's the same with mental illness in many ways, where the disease of the mind takes over the person and they lose their knowledge of wrongfulness or their knowledge of the action, the knowledge of their behavior by want of that mental illness. We don't hold that person criminally responsible, but we do detain them for treatment. It's a bit more complicated than that, but we do detain them for treatment. Perhaps that's something that might happen in the future.
Or would it be the manufacturer's fault, the engineers at the end of the day, for not creating a device which was secure enough that was, couldn't be hacked? Is that also maybe something?
Absolutely. There's civil law issues there. Certainly they could be sued for a faulty device.
Yeah.
You get a car that is prone to crashing. Well, you can sue the manufacturer. But criminal law makes it tricky, unless, of course, it was intended to operate in a way that caused the harm.
Yes.
And even then it can be difficult. It can still be difficult then for criminal law. Yeah, it's sort of the industrial manslaughter, which has always been a difficult one to prove.
Yeah.
Yes, criminal law operates at its easiest, if you will, where it's an individual performing an act that is in control of their behavior, subjectively knowing the behavior will return the consequence, the specific consequence that they are intending. And where you get a case like that as a prosecutor, you're more than likely to get a guilty plea because there's no defense, there's no available defense. But where you've got all these exceptions around actus reus or mens rea, or where the liability is at arm's length through a manufacturer, then you've got all sorts of opportunities, if you will, for defense. And the matter is contested and potentially goes before the appeals courts. And that's where difficult questions often end up, as might the whole neuro law and criminalization issue into the future. It's a tricky one. So we're looking as though we've got 5 minutes or so until we're at time. Thank you all very much for your chat questions. Tara and Alan, do you have any final thoughts, any final comments that you would like to add to close our panel tonight? Or
Do
today, wherever you are.
you want to go first, Tara? I'll have a think.
Well, I will say, please don't leave it up to us engineers to to work out how to safeguard this stuff. It's hard enough to make it work rather than thinking about other things. I think there should be more crossover. We're sort of, there's a lot of technology now, artificial intelligence and sort of human augmentations that are, you know, they're out there now. We're building them, and probably there needs to be more collaboration with the law to work out how we can navigate this new world that we're building.
So to echo Tara, I might finish by saying, yeah, please don't just leave it up to the lawyers. we need some input from engineers and neuroscientists and ethicists and philosophers of mind. As we
philosophers as well. This truly is a cross-disciplinary field, as I think with tonight's discussion has revealed. Thank you all so much, everybody, including those joining us and asking questions. Thank you to Tara and to Alan for your amazing insights. Let me just throw back to Marina now, who started us off with the introductions. Thank you all very much.
Thanks, Tyrone. So as the National Convener of the Australian Society for Computers and the Law, it's my pleasure to thank our panelists today, and also Nicole, who wasn't able to join us, of course, Simon in the background for all your assistance and for a thought and brain stimulating session on neurotechnology and the law. You've been very generous with your time and sharing your thoughts and expertise with us. We certainly hope that there's much more multidisciplinary conversation on these topics. Special shout out and thank you to the UK Society for Computers and the Law. Keep your great work going on. Now for some quick announcements. Okay, so you see on the screen there a number of our upcoming speakers and the topics that they'll be covering. We do run many events and we'll be delighted for you to join us. Here's some login information. So one of our next events will be the Reasonable Robot, where we'll be talking about can robots be reasonable and decision making generally. That will be a joint event with the University of Melbourne Centre for AI and Digital Ethics. And you can see there the link to register. Future histories, those of you who know Lizzie O'Shea, you'll know this is an event not to be missed. She's a human rights advocate, amongst other things, and she'll be speaking about how the history can actually help us in making better decisions going forward, particularly as we're more and more affected by technology. Those of you who want to get more into the technical detail, we're running a series of masterclasses, all complimentary. You're very welcome to join us. This is about converting human law or human readable code into machine readable code. And we've already had one of those sessions on with Data 61, and there are 2 coming up in the near future. Please feel free to join us and stretch your skills as lawyers. There you go. There are a number of URLs for you to follow and for you to subscribe to our mailing list. If you're very interested in rules as code, you may like to join our community, which you can see the link there. And also another big thank you to our Society for Computers and Law over in the UK for all your assistance today. If you'd like to follow their good work, you have their URL on the screen. So that's all from me. Enjoy your evening and your morning, Simon. Thank you all for joining us, and to our wonderful panelists. I know no one else can really clap at this stage, but I can. So thank you very much. And I look forward to you joining us at future events. Bye for now.